Hello, everyone. This is Tom Fox back with another episode, and you're in for a treat today because Mr. Contrarian himself is back with us, Jon May. Jon, welcome back.
Thank you. It's a pleasure.
Jon, Jon, for those who may not recall your current role and what you've done for quite some time, what's the nature of your practice?
It's a combination, for the most part, I help other lawyers in complex cases develop creative solutions to what call otherwise intractable problems. I have a book, Who Says You Can't? Strategies and Tactics for Becoming a More Creative Criminal Defense Lawyer. So, all my career, I've written articles and lectured on problems that lawyers face where there is no definitive best practices for handling a particular problem. And now I'm going more into not necessarily best practices, but what would be the most effective way of addressing a situation. And I still have my own clients who I represent individually.
Jon, we're going to visit today about one of your more recent articles, which I think is entitled How to Fix the DOJ's Fatally Flawed Corporate Whistleblower Program. Why do you think that this is your third paper addressing this issue or series of issues? So you want to take us through why you think it's fatally flawed and perhaps even doomed to fail?
What's different about this issue from my other two is that in the first two issues, I developed the reasons why I believe the program is flawed and can't work. I mean, as I said, it's dead on arrival. The interesting thing is that very few people seem to realize this, and big law is using this as a lawyer's relief act by telling their corporate counsel that this is a game changer, something that will have a significant impact on how companies need to address their compliance programs, when in the reality, it's going to have no impact whatsoever. As you say, I'm sort of a contrarian, but this is, in my mind, so black and white that I don't know what DOJ, actually, I have some insight into what DOJ is thinking. I have no insight into what big law is thinking, because they had just not subjected the statute to any kind of critical inquiry. Let's begin with what I believe happened with the development of this program. It's called the Department of Justice Corporate Whistleblower Awards Pilot Program. And the reason why it's called that is they're only going to let it run for 3 years because not even they're certain that this thing is going to work. What it reflects, as I will go through the various flaws, is number one, the hostility of Department of Justice to whistleblowers. Now, the Department of Justice has seen just how effective the SEC has been in recovering billions of dollars of fraudulently obtained monies from illegal securities transactions. And DOJ is very responsible or very knowledgeable of how key tam suits, and just to explain what a key tam suit is, although some people call it qui tam, that kind of suit is a lawsuit brought by an individual on behalf of the government, as if it takes place of the, or steps into the shoes of the government and sues a party to recover money that has been defrauded from the government. That is, money that the government has paid individuals or a company for some kind of program like Medicare, where they should not have. An individual can sue because they have usually inside knowledge, and they disclose that to the government, and they file a lawsuit. And that program has been spectacularly successful in recovering money for the government. But the government has always been suspicious of whistleblowers because they're used to dealing with uh, criminals who snitches who provide them information, and they don't trust those persons. And there is an attitude, and I think it comes from the fact that a lot of DOJ officials have worked with big corporations who definitely don't like whistleblowers. And their attitude is that these people are really just out for money. And that is as far from the truth as possible, but it's sort of an idea, myth that a lot of people in and out of government have. And I can discuss that later because I'm going to get directly to your question why this provision is flawed. Now, in the articles that I have written, I've said it really helps when you read my articles to have a copy of what's known as the guidance in front of you, because the guidance detail, excuse me, the program. And I'm a big believer that you don't trust pundit, and that if you're going to hear somebody offer an opinion, look at the source material and make up your own mind. But I think if you look at the source material, you're going to come to the same conclusions. And in my articles, I quote large portions to illustrate why I believe the program is flawed. Let's look at the first part. The program repeatedly says throughout it that an award to a whistleblower, which can be up to 30% of the money recovered, up to $100 million, okay, is within the sole discretion of the Department of Justice. So somebody could give them information that leads to a recovery of $100 million, and the government could say, we're not going to give any money. Too bad. It does not create any enforceable right on the part of the whistleblower, no matter how arbitrary and capricious the decision is by the Department of Justice. And you would think that they would be motivated to pay whistleblowers. And if it weren't for the demonstrated hostility of the Department of Justice throughout this program, maybe you might have more confidence. You might have more confidence in the department. And also, it's real significant that the SEC, qui tam actions under the False Claims Act, are mandatory. That is, except under the most unusual circumstances, if a whistleblower has cooperated and provided information that leads to a recovery, okay, they are assured they will get their money. The SEC statute uses the word required. The SEC is required to pay the whistleblower for their information. Now, the SEC has the discretion to determine how much, depending upon the nature of the cooperation, which makes sense, but they have to pay. It's not within their sole discretion not to. And if the whistleblower believes they've been treated unfairly, they have a right to an appeal. Okay. Under the department's, which again is within the sole discretion of the Department of Justice, there doesn't create any enforceable rights. You can't go to court to say, look what I did for them. Also, under the federal qui tam, in the False Claim Act, where you file a qui tam lawsuit, it says that the person who brings the lawsuit is who's known technically as a relator, shall receive money. And the distribution of money under an agreement entered into between the Department of Justice and a company or a whistleblower has to be approved by a court. So even then, there's the potential for some kind of judicial review if the government is not treating the whistleblower fair, but not under this program. No right to review, no right to an appeal, no rights established for the whistleblower, and the award is within the sole discretion of the Department of Justice. Let's say the Department of Justice acts properly in 80% of the cases. You got 20% of people who have made a disclosure at great personal and financial risk to themselves, and they're getting zilch for their actions. That is the first reason why a whistleblower should have real concerns about trusting the government, and why I would recommend, if I were their lawyer, and I'm not a whistleblower lawyer, but for those lawyers who practice whistleblower practice, um, they should, of course, explain in detail that the risks involved. And one of the risks is no matter what effort they make, no matter what information they provide, at the end of the day, they may not get in court. So that's first problem. And like I said, under these, excuse me, in this article, I try to offer some solutions to these problems that could make this program work. And the solution to the problem is simply for the government to include language that either would create some kind of enforceable right that you could go into court, or simply says that except under unusual circumstances or circumstances that show that the whistleblower did not provide original information, or the information was not truthful, or whatever, that they will receive an award, and take out all this sole discretion. Okay, that is the first problem and the proposed solution. Here's the next problem. And this is, somebody could accuse me of maybe being unnecessarily distrustful of the Department of Justice on point. Point one is complemented by point two. And point two is that even if you do everything that would entitle you to an award, there may not be any money available to give you an award. And the reason is that under this program, you are entitled only to the net proceeds of a forfeiture. Now, let me explain what a forfeiture is. There are two kinds of forfeitures, civil and criminal. And basically, if the government can go into court and prove that someone has obtained money unlawfully in violation of some federal statute, the government can file a civil lawsuit. And if it proves its claims, forfeit, that it take back the money that these people received unlawfully. In a criminal situation, you have to have a conviction. And if you have a conviction and there are particular criminal forfeiture statutes, if those apply, again, the government can recover the money that the person received or entity received unlawfully. Now, forfeiture is a penalty that is exacted by the government, and the money that is recovered goes to the U.S. Treasury. It doesn't go back to the victims. There is separate procedure known as restitution. And with restitution is the means by which victims receive compensation from the wrongdoer for the money that the wrongdoer took from the victim. So you got restitution, okay? You've got forfeiture. Forfeiture comes first, okay? And it's the same pot of money that restitution comes out of. So sometimes when you're done with forfeiture, there's no money for restitution. And while it's possible for the victims to ask the Department of Justice to give them money from the forfeiture because it was really their money to begin with. The government is not required to give the victims money that was taken in the forfeiture. That just explains the situation. Take restitution out. Just consider forfeiture. There are times when by the time a forfeiture is ordered, particularly a criminal forfeiture, there may not be any asset left to go back to anybody. In a lot of cases, especially if you're dealing with criminals, sometimes the assets are overseas and you can't get to them. And sometimes these people have spent all their money on food and travel and jewelry and all that stuff. And again, it frequently happens that a forfeiture is instituted, but the government doesn't recover anything. But let's say that you do have a pot of money that the government obtains through forfeiture. Under this same pot of money is where an award under the whistleblower program can be used to compensate or to pay the whistleblower. But net proceeds also, not only does it mean the expenses that the government had in bringing a prosecution, it also means that when you have victims, other than when the government's a victim or big corporations, when you have people who are victims, they must be compensated fully from the money before the government has to pay the whistleblower anything. Now, this sort of creates a kind of restitution mechanism because unlike normal forfeiture, this creates essentially a guarantee that the victims are going to get completely made whole. Again, sometimes there's not enough money, there's not any money to pay a whistleblower. But here, once you completely compensate the victims, and the amount of the forfeiture is the amount that was taken from the victims. Once you fully compensate the victims, there may be nothing left for an award because net proceeds, you pay all of the victims first. You can have a situation where a whistleblower has spent a great deal of effort to assist the government, and the government has had a terrific recovery, $100 million. The whistleblower gets nothing. Okay. There's also another scenario. A whistleblower is only entitled to receive an award if the amount of money recovered by the government is over $1 million. Okay. And that's again, proceeds. SEC has the same rule. It has to be over $1 million before the whistleblower will get any money. Okay. If you pay all of the victims, all of the money that they were defrauded, that may take the $10 million. Let's say the victim's recovery is 9.1 million. Okay. The government will still collect $900,000, but the whistleblower won't get anything because the net proceeds has fallen under $1 million. Again, no matter how much money the government has recovered initially, a whistleblower loses out. Whistleblowers are some of America's most loyal, patriotic people. Certainly some of the most loyal employees because most whistleblowers go to their employee to tell their employer to tell their employer that a crime has been committed, not expecting any money from their employer, but because they are loyal to the company. They are outraged. Sometimes they've been with the company for years. They are outraged that the company is being used to commit a crime, and they want the responsible people fired. Okay. These people don't go to the government just because they can make a pot of money. They go to the government because they want to see the appropriate people punished. Now, certainly the government, whether it's the SEC or Department of Justice Fraud Division, make a big deal out of huge award, $100 million, 279, whatever. But the average was the average forfeiture is a fraction of that. And whistleblowers usually just receive enough money to compensate them for the years they have spent in providing the government with information. And because often the company learns of their identity, the loss of employment, being blackballed in the industry, not being able to get a good paying job again, and a whole host of other collateral things, sickness and divorce, sometimes the whistleblower goes into an arrangement with the government to provide information. They subject themselves to significant jeopardy and sacrifice. But again, how do you, as a lawyer, recommend to the whistleblower that they should provide information to the Department of Justice when the likelihood of recovery is so speculative? Now, that's not the case with being a whistleblower for the SEC or a whistleblower under the False Claims Act, because when those lawsuits are filed against the company, usually the company is a going concern. They're not out of business. They haven't been prosecuted, accused for a crime. Okay. So because the company is or corporation is ongoing, they have money still there. So a whistleblower lawyer has some confidence that, number one, they can advise the whistleblower client that if the agency, SEC, IRS, FCPA, makes a recovery, there will be money available. I think it's a very different situation than with this program that requires that any money that's left over, if there's any money, goes first to pay the victims. With the SEC's program and with the program under the False Claims Act, the money comes directly from the recovery. The money, there is no net proceeds provision where other people were paid off first. Entirely different situation. Now, you go for a situation where the government doesn't guarantee you any money. The reality is that there may not be any money available to pay you. Okay. Now, it gets even more ridiculous. The government won't pay an award if finds that you are eligible for an award under another program. On its surface, it might make sense for the government to take the Department of Justice to take the position if you've already been compensated for the information by the SEC or the Commodities Future Trading Commission or the IRS or whatever, you shouldn't get a windfall, being paid double. That's not it at all. You can't receive an award if you're just eligible for receiving an award from another agency's program, not that you've received anything. There are significant impediments to becoming a whistleblower for the SEC or a qui tam plaintiff under the False Claims Act. Circumstances which make it illusory or only theoretically possible that you will benefit or that you would receive an actual recovery. It's still with the SEC. Since the whistleblower program began, I think in 2011, the SEC, and remember, the SEC has less than 5,000 employees, and only a few hundred of those are investigators, as opposed to the Department of Justice, which has over 100,000. So in the years where the SEC's whistleblower program has been around, they have received something like 80,000 tips, of which they have given out something like 345 awards. Now, I haven't done the numbers, but that's a very tiny percentage of the people who've made tips. So if I'm a lawyer and I'm advising a client whether they should make a disclosure to the SEC, I have to tell them that you got a real good case. I've evaluated it. Okay. But the agency may not even look at your information because they are overwhelmed. This year, I think it's the biggest year for tips. They received 18,000 whistleblower tips. Okay. So being eligible is just an excuse by the Department of Justice not to make an award. Now let's look at qui tam action. With a qui tam action, you don't just make a tip to the government. You've got to file your own lawsuit and litigate your own lawsuit. And maybe the government will come in and take over the lawsuit and will do all the work after that. But these are contingency cases. So you have, when you go to a lawyer who specializes in qui tam cases, and they're mostly like healthcare cases, the lawyer is going to evaluate whether or not you have a claim worth pursuing, because the financing is going to come out of the lawyer's pocket. And if there's no recovery, the lawyer is out the expenses and then all the time that he put into it. As a result, something like 90% or more people who go to a whistleblower lawyer who specializes in these qui tam action don't get counsel, can't get counsel because a lawyer is just, it's like personal injury practice. Okay. If you don't have a certain threshold of injury, you're not going to find a lawyer who's going to take your case. So the government under its program could find you eligible for filing a qui tam action. But if you can't find a lawyer, and here's the other thing about that's sort of unique about qui tam actions under the Federal False Claims Act, you can't file a suit by yourself. You have to have a lawyer to file a lawsuit. And the reason is, the theory is, that this isn't said in the statute. This is federal common law. What the courts say is, you can't come in the place of the government as a private person, because a private person can't represent another party. you're essentially representing another. You have to have a lawyer. These are practical problems that the smart people at the Department of Justice have to know. Okay. They are so concerned about protecting themselves, giving the department an out so that they can say, we didn't pay the whistleblower. All right. So we're not tainted by whatever the whistleblower did. That they have created is they have created a program where nobody's going to want to participate because it's too chancy and there's too much potential jeopardy. Okay. Now let's go to the final problem. And with the whole eligibility thing in terms of my solution, cut it out. You don't need to have it in. It's stupid. It's counterproductive. So that's something you don't need to have in either. Now let's go to the final problem. Well, if you don't mind, I'll take it. My mouth's getting very dry. The final is that the Department of Justice under this program requires complete cooperation. What do they mean by complete cooperation? You will answer everything truthfully. Okay. That you will provide whatever information, documents that you have obtained lawfully from your company that you can give the government. Okay. But there we go. If it's necessary for you to testify before a grand jury, you will testify before the grand jury. And if they think it's necessary for you to testify as a witness, you agree that you will testify as a witness. And if they want you to wear a wire and go undercover, they do that too. Come on, guys and gals. You're not dealing with a person who's been indicted, willing to do anything to get a deal so that they can get reduced charges. You're not dealing with a criminal when you're talking about these whistleblowers. You're talking about an innocent person who has stumbled upon criminal conduct, has disclosed it to you, despite the risks that are so substantial, nothing else, just being fired. And you are treating them like a common criminal. And with the SEC's program, you're talking about a program where the whistleblower's identity is not revealed. Here, you are practically guaranteeing the whistleblower that their identity is going to be revealed. So their claim in their program of protecting the confidentiality of the whistleblower, well, I don't want to call it a scam, but it's certainly not true. So between the government's discretion not to pay a whistle and the potential that there won't be any money available to pay the whistle, and then you added to it this crazy eligibility thing, and then, I mean, I think this is absolutely immoral to take an innocent person and treat them like a criminal and say that they have to jeopardize their own life by going undercover and wearing a wire if it's necessary so that the government can make a case. I mean, if for no other reason, I think any whistleblower lawyer that recommends to a client that they should sign up for this program, no, I just can't see it. So these are the reasons why I believe that this program um, will ultimately fail. I mean, just going back to the solution, let's talk to us about the solution for the last. You don't need this provision. Government does not need this provision to protect itself or to ensure the viability of a prosecution. 99% of defendants in criminal cases, and almost 100% of corporate entities never go to trial. They either enter into an agreement or they plead guilty. So the government is going to be able to use this information to maintain and successfully close their case. You have a situation where you really need the whistleblower to be a witness, and you can't go forward with a case because of that. That's a small price to pay for having a program that creates all of these opportunities for the government. And it's always up to the whistleblower. If it's up to the whistleblower, you can always ask them if they're willing to testify. Some might. I just want to go back to another point regarding money that is paid to victims first. If you pay money to the victims first, as I've said before, you may not have any money left over for the whistleblower. But let's say you pay for the whistleblower, you pay the whistleblower an award first, and they get 25% of $100 million. So they get $25 million. There's still $75 million left to compensate the whistleblower. So again, you don't have to do this. In creating a program that has these provisions that you have created only serves to undermine what otherwise could be a very good program. So I've talked a long time. I have no idea how long I've been on, but that's what I'm saying. That's my position.
So here's the question I wanted to pose. In the corporate enforcement policy, it previously was called the FCPA Corporate Enforcement Policy. There was a presumption of a declination under the following conditions: self-disclosure, remediation, cooperation, and profit disgorgement. There was no fine and penalty assessed beyond profit disgorgement. There is still a provision in this program and this guidance where a company can avail itself of a self-disclosure and potential declination if they self-disclose to the government within 120 days after the whistleblower has
Mhm.
disclosed to the government. So, assume company meets that 120-day deadline and the declination program kicks in. So we've had a self-disclosure. We now have cooperation. We have remediation, and we get to profit disgorgement. Now, profit disgorgement is the amount of money of ill-gotten gain. If it's a contract, it's not the full amount of the contract, it's profit. And that could be 1 year, it could be 2 years, could be multiple years. So my question or my perhaps concern is that if a company meets that deadline somehow, and the only monies recovered are profit disgorgement, is the whistleblower really in less of a position than he was or she because they're going to get some percentage of that profit disgorgement? Or does profit disgorgement not fit into the definition of forfeiture as you understand it?
But I have to look at the guidance again. I think they have some language that includes other kinds of recovery under other kinds of procedures besides just forfeiture. I don't think it's a situation where if there's just disgorgement pursuant to an agreement that the whistleblower wouldn't be entitled to some recovery. Certainly, the whistleblower is likely to get a smaller percentage where a company has voluntarily disclosed and entered an agreement because the amount of money that a whistleblower gets depends upon the importance of the whistleblower's disclosure in the government's recovery. So didn't, if the whistleblower's information didn't play a significant role in the government getting the disgorgement, then they're going to get a lower percentage. Now, I would say that had the whistleblower not made a report to the company, wasn't going to make a disclosure to the government. But in the real world, that argument probably not going to fly.
So, John, unfortunately, we're near the end of our time for this episode. But before we leave, if our listeners wanted to connect with you or find out any more information on the topics we've discussed, what might be the best way for them to do so?
Best way is to simply send me an email. And my email is johnmay.criminaldefense, one word, @gmail.com. And I'll respond to an email.
John, thanks again for taking the time to visit with us. Thanks again for writing these 3 articles. You've given us a lot to digest. Hopefully, someone or ones are listening to some of the concerns you've raised, and I anticipate we'll have the opportunity to visit on this again at some point.
Thank you very much. It's always a pleasure to talk to you and be interviewed by you. Thank you, Tom.